Hello, everybody. It's great to see you all. I don't see you, but I think you probably see us. Good evening. Welcome back to America at a Crossroads. I think this is the longest break in 6 years that we've ever had. It's been 3 weeks since we've seen you. I'm Janice Kaminer-Resnick, and I'm delighted to welcome you on behalf of our leadership team, former Congressman Mel Levine and former Los Angeles County Supervisor Zev Yaroslavsky. A special welcome to tonight's guest, the remarkable Leah Litman, co-host of Strict Scrutiny, and most recently the author of Lawless, How the Supreme Court Runs on Conservative Grievance. I hope you can see this. Fringe Theories and Bad Vibes. We are thrilled to have her with us. Many thanks as well, and welcome to our moderator tonight, Madeleine Brand. While every week seems to bring difficult and troubling developments, the events of this past weekend and the events of today have been especially alarming to many Americans, including to our leadership of America at a Crossroads, and we suspect to much of our audience. In response, we are planning two upcoming programs, one in February and one in March, focused on the situation in Venezuela, as well as other global developments that are likely to remain urgent and topical in the weeks ahead. Please stay tuned for announcements about those programs. I believe one of them will be in the email you'll get after tonight's program at the bottom of the email. You can register for all of our programs through that email, those email links. As this year unfolds, whether in response to rapidly evolving events at home and abroad, or in anticipation of the critically important midterm elections, you can count on America at a Crossroads to continue bringing you outstanding experts each week to help us navigate another year marked by uncertainty and head-spinning news. Before we begin, a quick look ahead. Next Wednesday, January 14th at 5 p.m. Pacific, we'll turn our attention to an issue that receives far too little sustained focus. Our program, The Politics of Hunger, Confronting Poverty in a Time of Division and Crisis, will feature Abby Liebman. She's the CEO of Mazon, A Jewish Response to Hunger, and Bob Greenstein, founder of the Center on Budget and Policy Priorities. Both are preeminent national voices on domestic poverty and economic policy. That program will be moderated by Larry Mantle. And now, without further ado, please join me in welcoming Madeleine Brand, renowned host of KCRW's award-winning daily news and culture program, Press Play, and co-host of KCRW's legal affairs podcast, The Legal Eagle Files. Madeleine, thank you for always being here for us. The show is now yours.
Thank you so much, Janice. It's great to be back with you. And it is great to welcome Leah Litman. And just a brief introduction, she is a law professor at the University of Michigan, from which she received her JD and graduated summa cum laude. She clerked for Justice Anthony Kennedy from 2011 to 2012. She's one of the hosts of a very lively and fascinating legal podcast called Strict Scrutiny. It's part of the Crooked Media empire. She's a frequent contributor on the court and legal matters for the Washington Post, the Atlantic, MSNBC, and other media outlets. Her book, as Janice said, is called Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Welcome to the program.
Thanks so much for having me, and thank you so much for moderating.
Of course, it's my pleasure. Well, okay, before we get into the bad vibes, let's get into the bad hombres and talk about the Trump administration's actions in Venezuela. And they are claiming that this is a law enforcement operation, that it's not an invasion. They've tried to justify removing Nicolas Maduro by saying he wasn't a legitimate president, he was engaged in illegal activities that hurt the United States, etc. He, of course, has said that he was kidnapped and that he'll argue probably the U.S. violated international law by arresting and imprisoning a head of state. What is your take on the legal arguments so far?
It's honestly tough to disentangle all of the lawlessness, so I will just briefly try to touch on the international law and domestic law aspects of this. So, for purposes of international law, it's a clear-cut case of absolute no-no. So, under international law, like, you cannot use force as a tool of policy. Like, one state cannot invade another, in the absence of a UN Security Council resolution or an attack on that state. And none of those predicates are here. And this is just a basic foundation of the UN Charter, which is in a lot of ways the foundation of the current international order. So the military invasion of Venezuela, I think, definitely violated international law. And the difficulty, of course, with international law is, well, what happens when there's a violation? And so much of international law is enforced by the response of other countries. And so far, we've seen kind of a range of responses, with some countries being willing to outright, criticize and say the Trump administration violated international law, with others being more muted, I think, because they are concerned about possible retaliation. On the domestic side, I think the law is a little bit more murky, but it is still clear that the Trump administration violated it. So under our constitutional system, the president is only supposed to have those powers that the Constitution specifically assigns to him or that Congress has delegated to him. And under the Constitution, the Congress has the power to declare war. However, it is understood that the president has the power to repel an imminent attack. If troops that are lawfully stationed somewhere are attacked, the president has the power to respond. That's not the case here. And I just note that their claim that what they were doing was domestic law enforcement is belied by basically everything they have said and done since then. Because, of course, now, Donald Trump said we, the United States, are running the country of Venezuela. Secretary of State Marco Rubio attempted to walk that back and say, no, we're just coercing them, to govern as we see fit. None of those things are remotely part of domestic law enforcement. And so it already seems like, to the extent this is ever about domestic law enforcement, and I don't think it was, nothing we have done since then, right, is consistent with that claim. And in any case, the idea that the president has the authority to invade a foreign country in the course of executing a warrant, is inconsistent, with the idea that under the Constitution, executive officers are only supposed to be able to do what is necessary and things that they have a legal basis to do in the course of executing these warrants. So, the memo that they are relying on was actually written by, the Attorney General during Trump 1.0, Bill Barr, when he was a lawyer in the Bush administration, and before that, the Reagan administration. And that memo took the frankly outlandish position that the UN charter, was not binding on the United States, which again would just be a wildly catastrophic and destabilizing, legal proposition to the extent it was correct. So that was a rough attempt to explain, not a lot of law there.
I'm wondering if the judge in this case, who, by the way, is 92, and
Yeah.
there has been an op-ed calling for him to recuse himself based on that. I don't know where you stand on that, if you stand on that. But he before him has basically the indictment, right? He's not concerned with how the prisoner got to him. So he won't be looking at the international law aspect of it, as far as I understand, right? So he'll just look at the indictment. So is it probable that he will order a trial, that this will actually go to trial?
I think it's quite likely that this will go to trial. You're correct that courts basically only assess their jurisdiction based on whether, the individual is in that jurisdiction, and they are not concerned with how they got there. So the court isn't going to be asking, did you illegally render, Maduro, Flores, and their child, to that area. What they will be assessing is whether he has what's called a head of state defense. And the leaders of foreign countries can claim head of state immunity. And as you were kind of previewing earlier, it's likely that the Trump administration will say they don't recognize Maduro as the, legitimate lawful head of state. And in the past, courts have been willing to defer to the executive branch's determination about who is and who isn't a head of state. Now, just because they're willing to defer doesn't mean they're willing to say yes to anything, but that's going to be an issue here.
As opposed to Noriega, Manuel Noriega in Panama, who was not a head of state.
Exactly. He was just a dictator who served alongside, right, a string of presidents. He was never elected. Maduro now has been exercising the powers of the head of state for several years, controlling the military, governing the country, et cetera, et cetera. So yes, Maduro has a much stronger, head of state defense claim, than Noriega had.
Right. So I'm also curious about, Trump has decided or argued to use the Alien Enemies Act as a way to deport Venezuelans accused of being part of this Trinidad gang. Now, if the United States is running Venezuela, how can it then use that argument? And I mean, maybe I'm being a little facetious there, but how can the U.S. then be at war with itself if it's quote unquote running Venezuela? So, what happens to that argument when it comes to deporting Venezuelan migrants?
So the U.S. Court of Appeals for the Fifth Circuit is actually set to hear, the case about, the Alien Enemies Act later this month. And I have no doubt that this is going to come up during that argument because part of the Trump administration's invocation of the Alien Enemies Act was the already outlandish claim that the Maduro regime was really operating in conjunction with Tren de Aragua, or Tren de Aragua was effectively, infiltrating the Maduro regime. And so the two were inseparable. But now, Trump has deposed Maduro, but he has left in place the Maduro regime. Like he said, he wanted to work together and declare the vice president, the leader of Venezuela. He has left in place the entire military, that is the apparatus, that Maduro used to actually stay in power and exercise power. So again, as their actions in the aftermath of the invasion of Venezuela, basically revealed the lie that was, their initial claim that this was just domestic law enforcement. Everything they have done, over the last few weeks has only underscored that the basis they had, their stated basis for invoking the Alien Enemies Act, was always false. It was always an invented narrative. And that is really the core of so many of this administration's, lawless antics and abusive exercises of authority.
So I just want to talk about one more thing in the news before we get to the book, and that happened today. Speaking of immigrants and ICE actions, there was this fatal shooting today in Minnesota. And so um, wondering whether or not this ICE agent who apparently shot and killed this woman who's an American citizen would be able to be charged under US law.
The short answer is yes, he could, and I hope he will be. For those of you who have not seen the videos, they are deeply disturbing. I would nonetheless encourage you to try to watch one because what you will see is a murder. There's no other way of describing it. An officer shoots this woman at point blank range, in the head as she is trying to escape. And if you read the account of her wife, the woman is 37-year-old Renee Nicole Good. She's the mother of a 6-year-old child, and she and her wife went to drop off their child at elementary school and saw ICE activity there and in their neighborhood. And so they exercised their constitutional right, to film federal officers who were engaged in legal violations. And, in the course of that, Renee ends up shot and killed. The administration has issued an absolutely horrendous statement, labeling her a domestic terrorist. And again, I would just urge everyone to watch the video and see for yourself. This administration will turn on anyone and characterize anyone as a threat, the second they stand up and attempt to exercise their rights. But to answer your question, federal officers can be prosecuted under state law. They are not immune from state law. Their defense is if they are acting, in the course of and in furtherance of their official duties. But of course, the response by the state, if the state were to prosecute the case, would be you weren't exercising in the course of your lawful duties. You were not acting in the scope of your duties. You were committing a murder. Nothing you did was remotely necessary for defense, of federal personnel or federal property. Nothing you did was remotely necessary for the enforcement of law. And so it will be a fight about whether the officer's actions were in furtherance and within the scope of their official duties. I think the video makes clear they were not. And so, yes, this officer can absolutely be charged with murder, in violation of state law.
What about in self-defense, though? I think that's what they're claiming, that she was trying to run down this officer and he was just firing into self-defense.
Yeah, so that is a defense that anyone, whether they are a federal official or not, could raise.
Mhm.
But again, I think the video really undermines that claim. The officer is standing to the side of the vehicle, and, goes up against the window and fires the weapon. They were not, in front of the car. There was if you watch it, it does not seem like the car is aiming itself at the officers. They were, together with other people attempting to like circle around and like see what the officers were doing.
And this is, I don't know if this is the first American citizen who has been killed in these ICE operations, but there have been other murders or other killings, I
Yes.
should say, of people in the course of these ICE operations. Do you know if there has been any kind of prosecutorial action related to these killings?
Not that I am aware of or that I have seen. I do know that Minnesota Public Radio reported that the ICE shooting and murder today is the first shooting and murder in Minneapolis, of 2026, and was committed by an ICE officer.
Okay. Well, all right. Let us get to the book and onto the bad vibes, as you call them in your book, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. And of course, we've been taught to think that the Supreme Court is a place where the rule of law reigns, where the justices soberly apply case law and the Constitution to their decisions. But you argue that the court actually has become lawless. It's running on quote unquote vibes. It's no longer applying the law to its decisions. So explain what you mean by bad vibes.
So by vibes, I mean to draw a pretty point in contrast with what people think of when they think about law. As you were describing, people think about law as something that is objective, that we can all sit down and agree has a right answer. If we just think about it or look, hard enough, we will find that correct answer. We think of it as something that is, external to us, again, that everyone should be able to see and recognize for what it is. Vibes are obviously more loosey-goosey, and I mean them to refer to things like someone's innermost feelings, right? Like, what do I feel triggers me, or what upsets me, or what makes me feel like I'm being attacked. They can also refer to things like the atmosphere of a political party, and the general, gist of the feelings and sentiments, of a particular political movement. And so that's what I mean by vibes. They're feelings, opinions, the zeitgeist, things that can't really be pinned down and aren't necessarily more to, facts or reality.
So I guess the Supreme Court, I guess, has always had a point of view, or people have points of view. They're, in fact, nominated by presidents who have points of view. They either want a liberal or a conservative justice. How is it more, in your opinion, running on vibes now than it has in the past?
Yeah, so I think for a few different reasons and in a few different ways. One is that the court has become more partisan, even though in the past it has been ideological. And what I mean by that is, in the past, of course, you're right, justices have views about what equality is or what liberty is, or what a constitutional guarantee of separation of powers means. But those views weren't necessarily reliably tracking the views of a political party in the same way that they are now. If you look at how the court used to function, it would not be the case that all of the Democratic appointees were on one side and the Republican appointees were on the other, even on these big ticket, high political salience issues. That's just not the case anymore. On these big matters of voting rights, racial discrimination, sexual orientation discrimination, discrimination against trans people, you name it. The division between the court's Republican appointees and Democratic appointees is really hard to miss. And so ideology is now a really predictive factor and strongly correlated with the justice's legal views. And that makes the court look and function a lot more like an elected branch of government. And I think that really brings us back to, well, if they're just going to act like people who are elected politicians, why would we allow, the people who are not accountable, not directly elected, not subject to reelection to be making these decisions versus the people who are? A second way in which I think the court has now started to run more on vibes is you're right that, of course, it is impossible and a fool's errand to try and separate entirely someone's worldview from their approach to judging. Justices' experiences, and their background are probably going to inform, how they see things like affirmative action or sex discrimination or due process. But I think what has happened is the court is now much more willing to, instead of allowing those sort of views to help the justices color inside the lines or decide hard cases or resolve matters where the constitutional text isn't clear, now they're letting those feelings and their worldview dictate the outcome rather than using it to fill in the gaps. And I'm happy to give, some
Yeah,
specific
please give an
examples.
example from.
Sure. So I think the one of the most pointed examples is Shelby County versus Holder, the decision from more than a decade ago that dismantled a key part of the Voting Rights Act, the preclearance regime that had required certain states with especially violent histories of racial discrimination in voting to get the federal government's permission before changing their voting laws or policies. And when the Chief Justice wrote an opinion striking down, the preclearance system such as it was, he said it violated this principle that he called equal sovereignty, the idea that Congress had to treat all states the same. That principle is nowhere in the Constitution. It is belied by so much constitutional history. I mean, the Voting Rights Act was enacted pursuant to the Reconstruction Amendments. Guess what the Congress in Reconstruction did? They treated states differently than one another, particularly states that were formerly in the Confederacy. In order to substantiate his claim that there was a principle of equal sovereignty, the Chief Justice literally had to insert a misleading ellipsis into a quote from a prior case in order to make it say, the exact opposite of what it actually said. Because, of course, prior cases had said there is no doctrine, no guarantee of equality of the states once a state is admitted to the Union. The Chief Justice, however, changed the meaning of that quotation to say the doctrine of the equality of the states, doesn't prevent Congress from treating states differently according to present day conditions. That's not what the prior case said. So there are just many different examples of instances where it is just apparent that the justices aren't doing law. They're not faithfully following anything like constitutional text, history, or doctrine, and instead, something else is driving their opinion.
And are you saying it's all the justices or just the conservative justices?
Um, So the Republican appointees do it worse. I don't have an example where the Democratic appointees are inserting misleading ellipsis in order to strike down a federal statute. But again, that's not to deny that the Democratic appointees' worldview, informs their consideration of these issues. I have no doubt that Justice Sotomayor's experience, with racial discrimination and affirmative action, partly colors her view that there is a meaningful difference between racial subordination and affirmative action. But, again, I haven't seen her say something that runs so precisely counter to, constitutional text in the court's prior case law.
But I think also what you're saying, if you don't mind me trying to paraphrase your book, when you talk about conservative grievance, is that the court in its conservative majority is trying to undermine the protections for racial and gender and sexual minorities because it's feeling that the majority, if you will, is getting a raw deal, that there's a sense of grievance on the part of, white men, and that there has been a shift too far in the other direction, and that the court needs to correct for that. Can you elaborate on that?
Yeah, so conservative grievance is one of the bad vibes that I think this court most frequently traffics in. And of course, everyone has probably seen or recognized elements of conservative grievance in electoral politics, in the Republican Party. I mean, Donald Trump basically ran in 2024 on the claim that I am your retribution. The idea that his entire base, the Republican electorate, was the victims of some great conspiracy of democracy, or I don't even know what. And it's a similar through line that animates, the different areas of law that I talk about in the book. The idea being that, different societal changes, evolving political views, evolving social views, the increased inclusivity, right, of the modern electorate, all of that has made it harder, to be a conservative white man because you are no longer entitled, to hold all of the power, to hold all of the social capital. And so they treat those societal changes as basically evidence of, discrimination against, and prejudice against white social Christian conservatives. I think you can see this in some ways most clearly in the law on LGBTQ equality. Obviously, this is an area where the law has changed pretty rapidly over the last 20 years. It was a little over, I guess, 20 years ago at this point, that the court said states can't make it a crime to be gay and criminalize, consensual sexual intimacy between consenting adults. Almost a decade later, the Supreme Court says states can't deny gay, lesbian, bisexual couples the ability to marry. And accompanying those legal changes were societal changes. The overwhelming support for marriage equality has increased, manyfold over the last few decades. And what the Republican appointees have done is they've said, well, that means that people who are opposed to marriage equality, they are now a beleaguered minority that is in need of judicial protection from the big bad, societal majority that now believes gay people should be able to get married. And so if they've twisted, the increasing societal support, and democratic and legal change, in support of LGBT rights as somehow a conspiracy, against religious and social conservatives. And they use that as a basis to give religious and social conservatives effective license to opt out of civil rights protections for the LGBT community.
So are you talking about the Masterpiece Cake Shop case?
Masterpiece Cake Shop is one example. That's the case of the wedding baker, the cake baker, who didn't want to make a cake that celebrated a same-sex wedding. There, the Supreme Court said Colorado couldn't apply, its non-discrimination law to penalize the baker. But the more recent case, 303 Creative versus Elenis, is the case where, again, the court said Colorado can't apply its non-discrimination ordinance, this time, to a wedding website designer who didn't want to make websites that celebrated, same-sex marriages. And in that case, as well as in Masterpiece Cake Shop, you see the justices writing about how the bakers or the website designers' views are now in the minority, but that is all the more reason to give them protection, as if the more unpopular they are, the more entitled they are to project their views onto everybody else. There was also a decision last term in Mahmoud versus Taylor, that gave parents the ability to opt their children out of public school instruction when that instruction included reading storybooks with LGBT characters. Again, the court was of the view that this is effectively, an attack on religious and social conservatives by exposing their children, to these inclusive storybooks.
But why not view it that way, that that they actually do think that they're protecting the religious rights of people who don't believe that they should be forced to bake a cake for, something they don't agree with. And why is that not okay to protect the rights of this particular person? Because as far as I understand, those two cases in Colorado weren't broad. They were just very tailored to the specific.
I think Masterpiece Cake Shop was somewhat tailored. I'm not sure that the wedding website case was, because in that case, what the court said is no state can force, any individual to express a message with which they disagree. And think about, how broadly that principle potentially cuts. What if a wedding website designer didn't want to make a website celebrating an interracial marriage or an interfaith marriage, a marriage of persons with physical disabilities. That might be a message with they disagree. The reality is there's a wide variety of conduct that is expressive, that somehow expresses a message. But the modern kind of civil rights regime is based on the idea that when you prohibit discrimination, against a group based on their identity or status, if you prohibit everyone from engaging in that discrimination, you're not discriminating against the, religious believers who might want to engage in that discrimination. This was part of the litigation concerning, the Civil Rights Act and its prohibition on racial discrimination. This was part of the litigation surrounding bans on interracial marriage. States as well as, religious believers attempted to say, under my religious views, I believe in a separation of the races. And the court said, well, but what the state is doing here, their purpose is not to force you, right, to express a message. The purpose isn't to attack your religious beliefs. Their purpose is to guarantee the equal rights of this community based on their identity and their status. So in some ways, like, it's just not about you, right? It is about the civil rights of another group. And if we are going to live in a pluralistic society, I don't have a right to opt out of laws that might run counter, to my particular beliefs, so long as those laws aren't targeted at me, because of my beliefs. And I just don't think there's any evidence that, laws that prohibit employers from discriminating, against gays, lesbians, bisexuals, or transgender individuals are indeed a secret cabal, that is trying to attack, religious conservatives.
The conservative justices often rely on a concept called originalism, meaning they want to go back to what the Constitution really said and not read outside the lines. A strict interpretation of the Constitution to guide their decisions. And you take that apart in your book, basically saying that that is a way to express male grievance, to use that word again. Explain your reasoning there.
Sure. So part of the argument about originalism is really the social history and political history of originalism.
Mhm.
The idea that the justices had gone wrong, when they departed from the original meaning or the original intent of the Constitution, actually started making waves as a way of criticizing Brown versus Board of Education, the Supreme Court's decision invalidating segregation in public schools. And then it really picks up steam during the years of the Reagan administration, when the Reagan administration started fusing, that administration's views on social policy, including gun rights, including rolling back abortion rights, including challenging women's rights. They started fusing that approach to social policy with originalism. And the idea was, the Warren Court and these courts that had recognized the civil rights of groups that weren't always included in the country had gone wrong from departing from some righteous past. And that righteous past had to be restored. When Reagan's Attorney General Ed Meese, gave his first speeches on originalism, he said originalism is the way to attack what he called, the radical egalitarianism and libertarianism of the Warren Court, the court that decided Brown versus Board of Education, the court that invalidated bans on contraception. So originalism as an ideology, right, and as a political movement was really trained on rolling back a lot of the civil rights movements, of the 1950s, 1960s, the feminist movement of the 1970s. And when you think about it, as a methodology, originalism kind of works well to that end, because what originalism tells judges is, well, in order to decide what the Constitution means today, figure out what it meant when it was ratified in the 1700s. Well, who was it ratified by? Who was it written by? A group of white property owning men, who, when they drafted, the protections for liberty, probably didn't have women in mind, and women couldn't vote at the time. So what sort of laws were passed? Laws that didn't recognize women as full and equal citizens. And originalism directs judges to that time and tells them that is what you should be interpreting the Constitution to mean.
And so that has picked up steam since the 80s, since Ed Meese came, first floated that, correct? And
Yes.
now it's seen as just that's part of how the court operates. Um, so how do you see that as actually informing recent cases such as Dobbs or recent cases, not just Shelby, but the other recent cases that have watered down the VRA?
Yeah, so originalism has been incredibly successful, as both a political movement and, a legal method of interpretation. I think in part because of the close relationship between the two. A judge, when they are nominated, for a judgeship or a position on the Supreme Court, can testify before Congress that my methodology is neutral. It's originalism, right? They can describe it with like a simple formula and an answer. And originalism over the last several decades has kind of gained a foothold and additional traction, in right-wing legal circles, right, and in academia, as, right-wing think tanks kind of fund more scholarship, right, and thinking about originalism. And so then you have this copious amounts of legal scholarship all about originalism, and that too helps it make it seem like more legitimate and more serious. But I think, you can bracket all of the more academic-minded and academic accounts of originalism and just look at how does originalism function in the hands of the Supreme Court? And it is remarkable the extent to which originalism manages to track the Republican Party's platform, on issues ranging from gun rights to abortion to voting rights, which the court is using originalism and poised to use originalism to roll back. And I just think it should be striking to people that a method of constitutional interpretation that is supposedly so neutral just happens to map on so neatly, to the political priorities of one of the two major parties.
Well, so how does that happen? Are there secret meetings in smoke-filled rooms or maybe vape-filled, I don't know, rooms that we're not a party to, where they hash out the whole philosophy, oh, we want this, and so we will take, you guys take this court decision? I mean, I'm being a little facetious again, but is there any kind of organizing body
Yeah.
that is working to coordinate the Republican or the far-right conservative legislative priorities, perhaps that Russell Vought has and others, with the Supreme Court and the cases that they take and then argue or decide?
Yeah. So I guess I would say whether or not there are secret meetings, I'm certainly not invited to them. It is remarkably successful and can function without them. And I'll talk about how it can function without them. You have these programs and societies and institutions like the Federal Society, like the Heritage Foundation, like so many other organizations that are funded, by right-wing money. And what they do is, they fund these right-wing public interest organizations that bring cases, that are seeded by the scholarship and advocacy of people who are funded with right-wing think tank money, right, or right-wing fellowship money. And then you also have, right-wing money helping fund organizations like the Federalist Society or the Heritage Foundation that help to identify people who are true believers, who will, when they are appointed to the court, do the things, that matter so much to the movement. And then once they are on the court, being part of those circles, right, continuing to attend all of the Federalist Society events and their speaker series helps reinforce that view and kind of signal to the justices, this is where your community is going. Like, this is where our priorities are. But, on that secret meeting front, you joke about it. But there are things like originalism boot camp, or I know, or, fellowships that are funded by groups like the Heritage Foundation that are really available, right, to academics, right, who are originalists, right, and are friendly with the Heritage Foundation, Federalist Society, and are open to students, right, who profess those same views. Are those secret meetings? I'm not sure, but I also know these organizations will fund events where they will invite judges as well, to be trained in the proper way of doing originalism, textualism, law and economics. And it's just no accident that, the organizations that are funded these things signal the right way of doing them is to reach these right-wing results. So it's really this entire ecosystem. It's no one particular thing where, someone calls up Justice Thomas and says, here's what the Federalist Society thinks, do that. It is instead an entire network, that is well-funded and manages to reinforce, the set of beliefs, of that political movement.
Well, speaking of shadowy rooms, let's talk about the shadow docket. And the court has been using this a lot recently to issue some major rulings. And there's a lot of legal activity happening in the second Trump administration. But some of these shadow docket rulings have really taken on big issues, and they've led to things like under agreeing to the civil service firings, for example, letting Trump carry
Yes.
that out, allowing racial profiling in ICE raids. That was a shadow docket decision, and defunding scientific research and all sorts of other things. So, how are they allowed to do that? I guess they're allowed to do whatever they want, but in a certain sense, unless they are impeached. But why are they doing this instead of hearing full arguments and issuing more traditional rulings?
Yeah, so just briefly, they kind of can do whatever they want because Congress has let them. It used to be the case that Congress exercised more control over the Supreme Court's docket. Congress used to tell the Supreme Court, you have to hear these kinds of cases, right? And used to define their jurisdiction. Now the Supreme Court has near plenary control, to decide what cases they hear, what issues, right, they will hear in those cases, whether it even issues an opinion, and so on. And that's really how the shadow docket developed. And it has come to be abused, but it reflects, something that is needed, which is sometimes there are emergency applications to the Supreme Court that require the justices to act quickly and sometimes without releasing a full opinion. The traditional example, of course, is death penalty litigation and death penalty stays. When a state or issues, a warrant of execution, an individual who is sentenced to death, might ask the Supreme Court for a stay of that execution to allow them to challenge, for example, the method that the state is going to use to execute them, which they won't be informed about, until the state actually signs their death warrant. So there are good reasons for why, certain kinds of emergency applications, can and should be filed, at the Supreme Court, and the Supreme Court can and should be able to act expeditiously and not always without opinion. The reality is that this court has just come to abuse that because what happened during the first Trump administration is that administration began asking the Supreme Court for emergency relief, anytime they were faced with a lower court ruling that went against them on some policy they really wanted to implement. And the Supreme Court started treating that as emergencies, giving the Trump administration these extraordinary forms of what are supposed to be emergency relief. And that just invited more of these requests. And the Supreme Court kept saying yes. And it's like, if you give a mouse a cookie, if you give a fascist a cookie, right, they're just going to keep asking. And that's what happened. And I think the Supreme Court views these shadow docket requests as frankly a quite convenient way, to give the Trump administration a lot of what it wants without the Supreme Court having to squarely uphold the policy, issue an opinion with reasons, and associate itself with the frankly catastrophic effects of these policies. You're right, the Supreme Court allowed, the Los Angeles ICE enforcement practices, to continue to engage in racial profiling, to stop people, to detain them, to question them, on the basis of their apparent race, ethnicity, whether they spoke with an accent, the kind of job they had, etc. And we've all seen, daily reminders of just how grotesque officers behave, when they are told they can do that. And those are the sorts of things, that the Supreme Court has allowed, and yet they have also given themselves, a fair amount of space between themselves and those policies, by not issuing these fulsome opinions, explaining their reasons, and having to own them. Because when they do these things on the shadow docket, they're harder to report. You don't have an opinion. What are you supposed to say? You don't know when they are coming in advance. Sometimes they are released late on a Friday night. And so all of that, I think, makes it easier for the Supreme Court to fly under the radar and give the Trump administration so much of what it wants.
Okay, let's get to some of the many, many good questions that we have from our viewers. What is your prediction of what the court will do with birthright citizenship?
I think they will invalidate Trump's executive order and say, the 14th Amendment means what it says. It means what it has always said. I mean, if you look at the drafting history, like the actual original meaning of birthright citizenship, there were actual debates in Congress where some congressmen said, hey, if we ratify this, the children of immigrants are going to be citizens. And people said, yeah, they are. right? Everyone recognized this. So I think the court is going to strike down that particular executive order as just too far afield. It is frankly not a core part, right, of the Republican Party platform, right, or establishment Republican politics. And I think they will use that in part to give themselves some additional credibility, from what they have been involved in for the last year.
We talked earlier about the Minnesota shooting, and Merlin asks if this would fall under qualified immunity. In other words, would the officer be shielded because of their job as an immigration agent?
Yeah, so just quickly by way of clarification, qualified immunity is a defense that officers can raise when they are sued civilly for damages. So that's not something that would come up in a criminal prosecution. This would be if, for example, the family, the surviving members of the family, sued the officer for damages. Qualified immunity shields officers from liability if they aren't violating clearly established law of which a reasonable officer should have known. Qualified immunity shields officers from all kinds, of liability and horrendous action. I do think the fact that there is video here, that depicts the shooting, would undermine a claim of qualified immunity, but it's not clear, right, that this officer wouldn't be entitled to qualified immunity given how capaciously, this court has construed it. In one particular case that I'm thinking of, the Supreme Court gave qualified immunity to a police officer who literally fired a lethal shot, a kill shot, at someone who was driving, at high speeds on a highway when there are already like a speed trap with spikes set up to stop them. So that should give you some sense for how extreme qualified immunity is. But one additional thing, qualified immunity actually wouldn't be the obstacle there. The obstacle would be what's called Bivens causes of action. There's no federal statute that allows you to sue federal officers for violating the Constitution. Instead, the Supreme Court has recognized that, the Constitution should give you that ability if you don't have some other remedy. At least they did so in the 1970s. This Supreme Court, however, has been extremely hostile to Bivens causes of action and has basically said if you are trying to sue an officer under a set of facts where we, Supreme Court, haven't recognized a cause of action, you can't sue. And because there isn't, an example of suing, an ICE officer, when you are in your car attempting to evade the officer, it's not clear that the Supreme Court would say you even have authorization to sue. And so that would block the suit before they even get to qualified immunity.
And it doesn't look like, so that's a civil suit you're talking about. It doesn't look like
Yes.
this administration would pursue criminal charges.
No, but that wouldn't prevent the state from doing so.
Right. Okay. So, all right, getting into executive privilege, because that's also a big topic, and executive power. And Stuart asks, do you think that SCOTUS, the decision Trump v. United States that created presidential immunity, could be overturned by a subsequent court, a subsequent decision, or do we have this for the foreseeable future?
I think that decision can, absolutely, be overturned, by a subsequent Supreme Court. I mean, we've seen this Supreme Court overturn case after case after case. Nothing stops a later Supreme Court from doing the same, with one of this court's precedents. I think the potential obstacle to getting that case overturned is it would have to be teed up. That is, there would have to be another case where you are trying to prosecute a former president for violating, federal criminal law. Not that many presidents actually exercise their official duties in ways, that violate federal criminal law because we don't tend to elect, those kinds of people to be president. Those examples are few and far between. But if the occasion were to present itself, right, if a future prosecutor were to attempt to indict again, right, a former president, nothing would stop a future Supreme Court from overruling, the court's immunity decision in Trump.
Well, could it possibly be that somebody sues Trump when he's out of office or tries to, and somehow it gets up to the Supreme Court and they have that opportunity to overturn it?
So it would technically only overturn it if he is indicted criminally. And so that would require, a state prosecutor or a federal prosecutor to try to indict the president. Seeing the modern Democratic Party such as it is, I am not confident that they would select an attorney general who would be willing to prosecute Donald Trump, although I wish they would.
Um, Susan asks, when the Constitution was written, was it intentional that the Supreme Court, one of the three branches of government, have no accountability?
No, it wasn't. I think at the time it was understood, one, that the Supreme Court wasn't actually going to be as powerful as it is today. At the time, being a Supreme Court justice actually wasn't that great a job. One Supreme Court justice resigned to be a governor because, the justices had to what's called ride circuit. They had to participate in other courts, not the Supreme Court, in these like physically taxing travels. The Supreme Court didn't hear that many cases. Congress didn't authorize it to hear that many cases. So it wasn't that important a job, and people weren't that concerned about it. Relatedly, Congress, has a lot of power over the Supreme Court, and it used to exercise that power. Congress has altered the size of the Supreme Court, changed the number of justices. It has altered the court's jurisdiction and said, we don't think you should hear these kinds of cases because we don't like what you're going to do with them. And so they've stripped the court's jurisdiction to hear those cases. They have sometimes required, the court to hear certain cases in order to limit its power. So the Supreme Court was never, I think, expected to be one this powerful or this unaccountable. And I think the fact that it has, become that way is part of, what is ailing our constitutional democracy.
Well, it gave itself a lot of power with Marbury versus Madison, right?
Yes, it did. Marbury versus Madison is a decision that announced that the Supreme Court has the power to decline to strike down federal statutes. That power, is and was so enormous. The Supreme Court only exercised it for a second time, you know, almost 50 years later in the infamous Dred Scott decision when they struck down the Missouri Compromise. So, for the first several decades, the Supreme Court only ever invalidated two federal statutes, over a period of 50 some years. Think about now how often they invalidate federal statutes, and you see how much like the Supreme Court's power has just become normalized when it didn't used to be that way, and it doesn't have to be that way.
So you said that Congress has in its history, uh, um, I don't know, clipped the wings of the Supreme Court in various ways. So envisioning a democratically run Congress and a Democratic president, do you expect that to happen now, given how conservative the court is?
Um, you know, I think it is difficult to predict our politics. I think the Overton window has changed so dramatically over the last 10 years. I don't know that 10 years ago I would have said a president will attempt to interfere with the lawful transition of power and overturn, the results of a democratic election. Things change very quickly, and so it's hard to know exactly how people will respond, and how our political system will respond. I'm not going to rule it out. To think that the Democratic Party will realize, what an existential threat this court is, not just to big D democratic governance, but to small d democratic governance and democracy as well. Um, and it's just hard to say, what they will do and what they might do. One indication that things are changing and changing quickly is, Joe Biden's evolution on Supreme Court reform. When he was, a candidate in the Democratic primary and initially elected as president, he wanted nothing to do with the Supreme Court and Supreme Court reform. He said, I'll appoint a commission to study it, when many other candidates were saying, I want to expand the Supreme Court. He appointed a commission, didn't give the commission the power to recommend anything. Fast forward 4 years to the end of his term, and he leaves office by saying, I embrace term limits and a constitutional amendment to overturn the immunity opinion in Trump, as well as ethics reform for the Supreme Court. So people's views can and do change, perhaps in light of what the Supreme Court, will do.
But he didn't push for it beyond that,
No,
right? Could have done
yeah,
more.
too little, too late, but still a change.
Yeah, exactly. So FDR threatened to expand the court,
Yep.
right? Or to at least get rid of all justices over the age of 70. Which is
Well,
fun.
he would appoint a new justice for every justice
Oh, I
over
see.
a
Okay.
certain age.
Okay.
Yeah.
So it doesn't it's not as dire as getting rid of. But anyway, so but that was because the court was stymieing his efforts at protecting workers and other
Yes.
in other instances too, and was quite conservative. And I guess the court got the message because then it started issuing more favorable rulings protecting workers' rights, etc. So I guess the mere threat of it was enough to have the court decide to go in a
Yeah.
slightly different direction. Do you think that that could happen now?
I think it is unlikely to work the same way today, for a few different reasons. One is FDR, did this after being reelected on a landslide and having supermajority control in both houses. Also, Congress at the time, is more responsive to national majority will. That is, if a candidate won, a greater than 50% share of the votes, they were more likely to become president. And a political party that won more than 50% of the votes was more likely to win control of the Senate and the House. That's no longer true today. And so what that means is, even if the Supreme Court looked around and said 51% of the country thinks we are the absolute worst and wants to expand the court, the likelihood that that is going to result in the election of a president and a Senate and a House that will think the same and do the same is frankly low enough where they don't really have to be as concerned as the Supreme Court was, during FDR's era. And so I don't think the political threat of court expansion would carry the same weight today as it did back then.
So let's end on some hopeful notes. And what do you think are some reasonable ways to fight back against a court that has become, in your words, lawless?
Short term and long term. Short term is I think we have to build a constituency, that cares about the court and wants to change the court. That is part of why, FDR was successful in changing the court because he got people to care enough, to actually invest in that issue, and, rally around it. And so I think educating people about what the court is doing and convincing them to care enough about the court, to vote based on, the kind of judicial candidates that people are going to appoint, that's a start. Also, frankly, criticizing the court, that can make a difference. We talked about the racial profiling decision in the National Guard case or the ICE case, out of California. I said the Supreme Court didn't write an opinion, and they didn't. Justice Kavanaugh did. And he ludicrously described, these ICE stops as brief and prompt and said ICE would just promptly let people go, once they showed that they were citizens. That's not what happened. And so what happened? Every time there was a documented stop of an ICE officer, stopping people on the street, dragging them out of their cars, right? Or these military raids, on Chicago apartment buildings, people started referring to that as Kavanaugh stops. And guess what? He hated it. Because in the recent National Guard case, he wrote a separate opinion in which he dropped a footnote that said what? Internally in the United States, ICE can't stop people on the basis of race. That is a remarkable change in position over the course of a few months, right? That is a result of public outcry and shaming. So make your voice heard, right? Educate those around you, talk to your representatives, and participate in you know, endorsement meetings, nomination meetings, and primaries, to pick candidates who will use their political power to actually make our institutions more democratic and representative.
You clerked for Kennedy,
I
and
did.
and he did, as Muriel has noted in the questions, recommend Kavanaugh to the court,
Mhm.
at least anoint him. What were your thoughts on that?
I think that is a stain on his legacy. Justice Kavanaugh has undone, so many of the decisions that, frankly, Justice Kennedy is celebrated for. Justice Kennedy was one of the Republican appointees who voted not to overrule Roe versus Wade. Brett Kavanaugh, undoes Roe versus Wade, precisely as he was appointed to do so. I think Justice Kennedy was always, a very conservative Republican appointee. He just also happened to be, someone who believed in LGBT rights and believed in the court's institutional legacy and trying to make the court seem, nonpartisan. And this is not a consideration that you see in the modern Republican appointees. And I think it was obvious that Donald Trump was going to pick someone, right, who behaved that way. It was apparent that Brett Kavanaugh would be one of those people. But we all have our blind spots, and that was one of his.
Well, thank you so much for coming on. This has been a great hour. It flew by, and I appreciate your thoughts and everything that you said today. And here's the book for people who are interested. It's called Lawless. Thank you so much, Leah Litman, and hope we talk soon again.
Likewise, thank you again for moderating, and thanks everyone for attending.
Thank you. It's my pleasure. And definitely tune in next week. Larry Mantle will be here and he will host a conversation called The Politics of Hunger, Confronting Poverty in a Time of Division and Crisis. And that is next Wednesday, again at 5 o'clock Pacific. And I will see you next time. Bye.